morning, everyone. We have a slight problem in that, although my camera appears to be working so far as the screen is, so far as the light is concerned, I can see from the icon that it isn't being recognised by the computer. So I'm not sure there is an easy answer to this. My inclination is, if everyone can hear me, to continue without a picture, because I could spend a long time wasting everyone's time scrabbling about. Can everyone hear me?
Yes, I can hear you.
I appreciate for council it's tiresome to get the occasional question from a disembodied person, but I think everyone will recognise my voice, and I think we will live with that. When we next have a break, I'll try and sort it out. It's a new problem. I switched my computer off overnight, and that's obviously how it's arisen. As I say, to spend time trying to work it out now will not be helpful. I heard Lady Justice Nicola Davies saying she could hear me. I didn't. Is that also the case with Council and Lord Justice Irwin?
Yes. Yes, my lord, yes.
Yes. Okay. Well, I'm sorry about that.
Yes, my lord.
I will ask my clerk to call the case on.
In the matter of Swift and Carpenter, case number B3 2018-2189, on Wednesday, 24th of June 2020, before Lord Justice Underhill, Lord Justice Irwin, and Lady Justice Nicola Davies, part heard.
I may just take advantage of my clerk's being here at the moment to say, Jinky, could you have a word with IT and see whether someone could be available to call me in the lunch adjournment?
Of course.
And we can try and sort this out.
Okay.
It's possible, but slightly unpredictable, that we may, one of the point I was about to discuss, we may take an early lunch. But I think on any view, if they call me at 1:05 or 1:10, we may be able to sort it out then.
Okay.
Very well. The other thing I wanted to say is some of us, including myself, are sitting in an non-air conditioned room. It's warm already. I suspect it'll be very warm by the end of the morning. You can't in fact see that I'm about to take my jacket off, but there will be no objection to those of you who are in the same boat doing so. Right, well, we now, I think, proceed with Mr. Watson's evidence.
My lord, before Mr. Watson is called, may I raise one issue?
Yes.
And that arises out of an indication at the end of yesterday, tweeting that he wanted to ask questions, as he put it, of this witness. And that is not a course to which we can agree. The order that was made in this case, which is Supplementary Bundle 2, tab 8, page 37, and I'm referring to the order of the 12th of March, when at the last hearing the Master of the Rolls was sitting with Lord Justice Irwin and Lady Justice Nicola Davies. There was consideration in relation to the actuarial evidence as well as other issues, and the order at paragraph 3, this is page 37 of SB2, was that the expert evidence would finish by 1 o'clock effectively today, if one translates that to now. Examination in chief limited to 10 minutes. There shall only be one cross-examiner of any given witness, and cross-examination should be strictly disciplined. And then over the page at paragraph 5, the parties were directed to file a draft timetable to be agreed if possible. Now, I would remind the court, obviously, that Mr. Watson is a witness on whom the appellant relies, and you'll have seen from the timetable that it is Mr. Sweeting, who is cross-examining Mr. Robinson, our expert. There was provision for all parties to ask questions of all experts, which we took up with Mr. Watson, but the appellant did not take that up with Mr. Watson. Effectively, Mr. Sweeting is asking, although he puts it as asking questions to cross-examine, effectively.
Why do you say that? The 4.2 says examination in chief. That's what you call asking questions of your own witness, to be limited to 10 minutes. So it's fine by the order. Isn't that right?
No,
misunderstood.
No, my lord, because he is the witness of the intervener. And so it is Mr. Allen who will be calling Mr. Watson.
Very slow of me. Of course, that's right. I see.
And my lord, but in addition, I don't want to labour this point, but in addition to that, as is obvious, Mr. Watson is a key witness. I will need all the time I can get, assuming there's no examination in chief. That'll be an hour, and I'm going to be hard pushed to complete in an hour as it is. So, for those reasons, I'm afraid I object to Mr. Sweeting wanting permission to effectively cross-examine Mr. Watson.
You presumably discussed this with Mr. Sweeting and ascertained what the nature of the questions is that he wishes to ask.
No, I haven't discussed it.
Why not?
Well, I don't know what he hasn't told me. I don't know what.
No, I mean, when you heard yesterday that he was going to do that, one would expect your counsel to say, I'll be objecting, or what kind of questions you're going to ask. Anyway, you haven't.
I haven't, and there hasn't been any discussion about what the questions are.
Well, I'm surprised and disappointed to hear that, but let's ask Mr. Sweeting.
Well, Lord, can I just make it clear that I'm not, in fact, anticipating asking Mr. Watson any questions, and I quite accept that the court gave directions about this, at the same time, in fact, as allowing the respondent to call two actuaries, Mr. Robinson.
Let's not go back over here, just stick to the point. You say you're not anticipating asking any questions, so this is a standard you go.
No, precisely, Lord. All I was saying yesterday is I don't know precisely what direction the evidence will take. Mr. Watson is an important witness. I simply wanted to make it clear that if there was a question which I thought was important arising out of the evidence and the cross-examination, then I would ask an indulgence from your lordships to ask that question.
Yes, well, I think that's a perfectly sensible way of approaching it. We won't necessarily give it, but and of course, Mr. Audland would have the opportunity to ask any questions arising out of your questions. But as you say, it may never arise.
Yes.
Okay, well, let's get on. And cross that bridge if we come to it. As I say, I think it's a pity the council didn't discuss this beforehand. But I'm grateful to Mr. Audland for reminding me, of course, that it's Mr. Allen's witness, and it's presumably therefore formally for Mr. Allen to call Mr. Watson.
Yes. So Mr. Watson is already on screen. Yes?
Yes.
So, can we start with your full name, please?
Brian Patrick Watson.
Before we do that, in fact, Mr. Watson, I think we probably need you to take the affirmation.
Okay, right. I do solemnly and sincerely and truly declare and affirm that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
Now you've taken the affirmation. Confirm your full name.
Brian Patrick Watson.
Your professional qualifications.
I'm a Fellow of the Institute and Faculty of Actuaries.
Your occupation.
I'm an actuary and a Director of Foster and Cranfield, or HE Foster and Cranfield.
Mr. Watson, just to amplify that, can you describe the business of HE Foster and Cranfield, what it does, the market it is in, and what you do?
Yes, well, Foster and Cranfield are valuers and auctioneers of financial interests, by which I mean life interests, reversionary interests in trusts. That also extends to things like charges. We've sold things like royalties at auction in the past. So unusual financial financial interests. My role, I'm a director, so sort of responsible with my co-director, co-shareholder for running the business, but I have almost all of the client contact, so I will be writing reports on the instructions of solicitors about partitioning trusts. I will be talking to potential vendors who are interested in selling a trust interest, life interest, reversionary interest, royalties, about what they might sell those interests for before I hand the case over to my auctioneer colleague who gets the thing sold, hopefully.
Mr Watson, you prepared a report for the purpose of these proceedings. Do you have expert bundle 2 there, please?
I do, yes.
And if you have dividers 16, starting at page 533.
533, yes, got that.
Do we have the first report you prepared dated the 31st of January 2020?
Yes.
And for completeness, if you turn through to page 555.
Yes, I have, yes.
Do we have there your signature?
You do, yes.
Turning through, then behind divider 17, page 559, please.
Yes, got that.
Do we see here responses drafted by you in response to a series of questions presented to you by the defendant?
Yes, you do, yes.
Respondent. And again at 574, your signature.
Just check for completeness. Yes, that's me, yeah.
And Mr. Watson, are those the 2 documents that you produced that set out your evidence and your opinions on the issues within your expertise relevant to this case?
Yes, they are.
If you wait there, there'll be some more questions.
Thank you.
Good morning, Mr Watson.
Hi.
Could we start on page 547 of your first report, please?
Yes, yeah.
Section 1023, you discuss the applicability of your 2 approaches, they being the market value or the fair and reasonable valuation.
Yes.
And if we look at 1024 and 1025, please. At 1024, you say if the intention is that a claimant will sell the reversionary interest, or that it will be held by a defendant, then the market value offers an objective assessment of the value of the reversionary interest.
I say that, yes, yeah.
At 1025, however, if a claimant retains the reversionary interest, then I'm not convinced that the market value is a fair measure of the value of the reversionary interest. You go on to say, well, perhaps I can ask you to read to the end of the paragraph.
So where have you got to?
Just the end of the first sentence. Could you read the whole paragraph yourself? There's no need for me to read it.
Do you want me to read that aloud or read it?
No, just to yourself.
Okay. Okay, I've read that, yes.
So you're saying there, as I understand it, that if the claimant retains the reversionary interest, you're not convinced it's a fair measure of market value because the value would be skewed in favour of the claimant.
Well, I think I'm not sure quite where I say it in my report, but I discuss the sort of concept of marriage value, which I've borrowed from another arena. And what I've said, there is a marriage value, market value of the reversionary interest, market value of a life interest, don't add up to the value of a property. So if a claimant takes the market value of the reversionary interest, I think they're getting something at less than full value because they should be paying, or paying for want of a better word, part of the marriage value. So I think it may be a solution to the problem that the court is trying to resolve, but not a totally perfect solution.
No. Essentially, as I understand it, you accept that if the claimant retains the reversionary interest, then you doubt whether it's an accurate market value of the reversionary interest in her case.
Well, no, it's because it isn't. If she retains it, if she is going to sell it, then it is an accurate. I think it's what the market. It's what the market would pay for it. I think if she retains it, then she's gaining some element of of the marriage value. So she's getting a windfall, whether it's more or less than the windfall that she gets under current arrangements, I don't know.
Indeed. And in this case, you're aware, aren't you, that Mrs Swift has bought her property without further borrowing?
I'm not sure that I was aware of that until I was listening to the proceedings yesterday.
And that being so, she is a claimant who owns at present the life interest and the reversionary interest.
Yes, I mean, I think my instructions were to produce my report as at the date of trial, which I think was 2018.
I'm not being critical in any way, Mr Watson. I'm just trying to establish where we are on your opinion. And the reason for that is that if a claimant retains both the reversionary interest and the life interest, that is never the case in any of your market sales.
If somebody who has a right to reversionary interest, remainder and in trust in the jargon I use, sells their reversionary interest, then we have a life tenant retains the life interest, the remainder or an investor holds the reversionary interest.
And with a claimant who has a full interest in the home or the property, that has significant advantages such as complete control over selling and moving at any time or mortgaging, etc.
Yes, I mean, that's a sort of an intelligent layman's, as an intelligent layman, then you must be right.
And that you would have thought that would affect the value, wouldn't you?
Well, I have been asked, I think I was asked, what is the market value of to an independent third party of her reversionary interest in the 900,000. Yes, so that's what I was asked to advise on.
Indeed. And you're saying that if she retains the reversionary interest, you're not convinced that that is a fair measure of the valuation in this case?
I'm saying, in the sort of words of this case, I think there's an element of windfall in there, or an element of the marriage value.
Yes.
So a less than perfect solution.
Have you read the joint statements of the other experts?
Other than Mr. Robinson's report, I've been through all of the other expert reports, but to say whether I've absorbed them, probably more of a skim read than a.
All right. I just want to avoid jumping around the evidence as much as I can, given time. But I think you were listening yesterday.
I was.
And one of the conclusions of the other actuaries, so to speak, the general actuaries of yesterday's evidence in the joint statement is that any market valuation approach requires the court to be satisfied that from that market they're able to draw a robust set of underlying assumptions from the market.
Yes. Yeah, I've certainly seen that phrase in the paperwork.
And you would agree with that?
Yes, yes.
And would you also agree that the market in question should be similar to the market with which we're concerned in this case?
Yes, I mean, not identical, but I think one that you can draw reasonable conclusions, yes.
Indeed. So I'd like to look at each of those points in turn.
Yes.
First of all, whether the size of the market and whether one is able to draw a robust set of conclusions from it. So can I ask you a few questions about it?
Yes, yes.
Would you agree with me that the market in which you sell these reversionary interests is tiny?
Tiny, small, yes.
And shrinking?
Well, it's certainly the number of sales in the last, as I gave in response to your inquiries, my responses, certainly small, and over the last 4 or 5 years and 4 or 5 years before that. I think it's unpredictable to say, what the position will be in a year's time, 2 years' time, and that's ignoring, as things stand, ignoring the possibility that there may be a way of assisting claimants in personal damages cases. Put that to one side.
I'm sorry to interrupt, Mr. Watson.
So all I'm saying is, it's certainly been smaller over the last 4 or 5 years than the previous 4 or 5 years. I don't think that that's necessarily a trend next year. You know, we may suddenly have 2 or 3 to sell. I don't know.
Well, let's look at the figures in your report at 540, please. Back a few pages. At the top of the page at 6.1.
Yeah.
You said that, as noted, the supply of reversionary interest has been limited in recent years, no more than 4 or 5 being sold at auction each year. That was something of an overstatement, wasn't it?
Well, it was an analysis that was based on experience, or our experience going back to the year 2000, and during that period, we never sold more than 4 or 5, and as I just said in my responses to your comments, questions on my report, the figures in the last 4 or 5 years have been 1 or 2, 0, 1 or 2, I think.
Yeah. Well, if we look at that, because we asked you a question about that, and if you turn to page 568 at the next tab, please, Mr. Watson.
568 I've got, yes.
It was question 11 where we picked up on that part of your evidence, and you were asked for each of the last 5 years, 15 to 19, please confirm how many interests you'd offered for sale, and you then listed them, and we see them there in chronological order. So the most in any one of those 5 years is 3 reversionary interests in 2016. There were 2 in 2015, and then we go 0, 1, 1. So on the face in the recent history of the market, on the face of it, the recent history would tend to suggest that the market is shrinking.
Yeah, yes.
To be almost non-existent.
I mean, I think it may well become non-existent, but equally, we may be selling 4 or 5 a year in the next 2 or 3 years. I don't know. I don't think it's a dead market, but it's a small market.
And if I'm afraid that this involves moving between your answers and your main report. So give me your main report, please, at 538, Ms. Watson.
538. Okay, yes.
And we're looking at 5.9, please.
Yes.
Your evidence in your report was that in terms of market sales, by way of example, over recent years, Foster and Cranfield have sold, and then you cite 3 cases.
Yes.
Now, you didn't give the years there, but we asked you to clarify them in the questions, and if you can keep a finger in that page, but turn to 559, please.
Yep.
You were asked to produce the particulars of the 3 cases of sales.
Yes.
And you then exhibit them on the following 3 pages.
I do.
And for their lordship's benefit and my lady's benefit, the dates are at the top left. I think you've written them on, haven't you?
Yes, they're in handwriting, yes.
So the first one is February 2011. The second one is September 15, and the third one is December 18.
Yes.
Incidentally, just for the sake of completeness, since the sale figure that you gave in 2019, have there been any further sales?
No, we're working on 2 at the moment, which may or may not come to market. They're at a slow gestation period.
Right, thank you. So your 3 cases are spread over a 9-year period.
Yes.
And of those 3 cases,
over 11 to 18, so that's the sort of 7 nearly 8-year period. Yeah.
My mistake. I'm sorry. My mistake. I apologise. And the oldest is from 2011. As a matter of interest, because you had 7 sales in the period 2015 to 2019.
Yes.
Why didn't you calculate an average based on all those sales?
What I should say, and apologies if this wasn't clear, those three examples were not intended as comparators from which to derive my suggested range of yields. They're examples I use in many reports, not just in the personal damages field, when I want to illustrate to people who've instructed me what the market for reversionary interest is like, and in particular that investors are willing to buy quite complicated reversionary interest. So I didn't, the suggested yields, my 6.2 to 7%, were not derived just from those cases.
But they seem to be, because if you look at the yields, if we turn, have you still got 538?
I'm there, yes.
So the yields you calculate, and you put these in an appendix. But
Yep.
if you turn over the page, case A is a yield of 6%.
Yep.
Case B is a yield of 7%.
And C is 6.8%.
Yeah.
What I did to come up with my 6.2 to 7 was look at the last 10 cases, which I think run from about mid-2013, through to the end of 2019, and 8 of those cases were within the 6.2 to 7% range. There was one a little less than that, so 5 point something or other, and one a little higher, 7 point something. So that 6.2 is derived, and you could say it's a coincidence that these three cases lie within that range. Alternatively, I guess I might argue that it demonstrates that there is some robustness to the market.
Why didn't you identify these other cases in your report if they formed the foundation of your yield calculation?
Because I didn't realise that it was something I should do. Or, I had those three examples. I wanted to demonstrate what the market in reversionary interest looked like, what sort of complications investors were prepared to put up with, and then went on to say that based on I didn't explicitly say this, but based on the last my analysis of sales since 2013, yields in the range 6.2 to 7% seemed appropriate. With the benefit of hindsight and the question you're asking, then I should perhaps have been more extensive in my examples.
Well, turn please to 567, Mr. Watson. 569, I'm so sorry.
Yes.
Do you see question 12?
I do, yes.
In question 12, you were asked to provide the details for requests 1 and 5 above, and those included requests for sales particulars.
Yes.
Now, you're telling the court that you based your yields calculation not on the 3 cases in your report, but on the last 10 cases.
Yes.
Why didn't you provide the particulars in answer to question 12?
It was simply a time issue. I can't remember the exact timing, but I only had a fairly short period of time in which to provide my responses, and didn't have sufficient time to dig those 10 cases out of files and put them into a presentable form.
You appreciate that one of the factors which affects the yield are the terms of sale, the terms of the trust, I'm sorry.
Absolutely, yes.
And without the terms of the trust, we have difficulty looking at how the yield in each sale might have been affected by those terms.
So I lost you part way through then.
I'm so sorry, I'll repeat the question. Without the terms of the trust particulars, which you were also asked to provide but didn't provide, we have difficulty in assessing how those terms might have affected the yield in any particular case.
Yes, and again, I think, as I said in my responses to you, some documentation that's provided by vendors when they offer an interest for sale is confidential, and the trust documentation is included that. And I guess what I would also say is that potential interested parties, potential investors, are given those trust documents. They'll review them, maybe with lawyers, maybe themselves. If they don't like the terms of the trust, then they won't bid. If they find them happy, they will bid.
And in the other cases which you've just referred to, we don't even know what the assets were because you haven't provided the particulars of sale.
Yeah, I accept you don't.
And the assets in the three cases which you do provide particulars of, which were the three on which you seem to base your opinion in your original report, are...
No, just to correct that, I don't base... as I said earlier, I gave you those three examples to sort of demonstrate the range of reversionary interests that we sold. I did not base my advice on my opinion on those three reports.
No, but if we turn to page 538, 539 to look at the outline details of those three cases.
Yes, yeah.
We can see that case A was a share of a farm.
Yes.
Case B was a portfolio of mixed stocks and shares and property.
Yes.
And case C was a portfolio of a number, I think it was about 8 properties.
Yes.
In your answer.
Yeah, absolutely.
So, all very different to the case with which we're concerned here, a single residential property in prime London.
Yes.
Can I ask you to look at 539?
Yes.
You say at 512, in each case, the actual yield the investor earns will depend on when the life tenant or property occupant dies and the value of the trust's assets at that time.
Yes.
Now, in these cases, we can see from your summaries, case A was aged, the life tenant was 67, that's line 2.
Yes.
Case B, line 2, aged 81.
Yes.
And case C, age 72.
Absolutely, yes.
We've no idea what the age is of your other cases, including in the 10 that you refer to.
No, other than I think I say in my report that the sort of reversions we sell, life tenants, tend to be at the older range of the range, older end of the range.
Indeed. And we see that how the yield is affected by age because the lowest yield is the youngest life tenant, the 67-year-old lady.
Well, it's a 67-year-old gentleman, but...
sorry, gentleman, I'm sorry.
I think... I'm not sure that I actually said, but that's in it. I don't say in my report, I think it's in the particulars, anyway, that's being presented. Yeah,
because that...
I don't think that there's a correlation between age and yield. That case is also the oldest one, as we say, 2011.
Well, there must be a correlation between age and yield.
No, not necessarily.
You have factored age into your calculation of the yield.
It could be. I mean, let's say, for example, we have we're selling a reversionary interest with an outstanding term of 10 years and one with an outstanding term of 20 years. The investor buying both of those might want a 6% return, but the one with an outstanding term of 20 years will have a much lower price than the one with an outstanding term of 10 years. So the yield could be identical for whatever the life expectancy.
Oh, indeed, but it would affect the price.
It will affect the price, but not the yield.
And therefore the valuation.
Yes, absolutely, yes.
And none of these examples involve anything remotely close to the age and life expectancy of the claimant in this case.
They don't.
You'll recall that at the date of trial she was aged 43 and had a life expectancy to aged 89.
Yes. Yes.
And you may be aware from the government actuary's advice upon the last setting of the discount rate that the average life expectancy of all claimants is 43 years.
I'm not aware of that figure.
All right. But you don't have any sales with claimants of that age.
No, and I make that point in my report, I think.
The valuation which is done for the purposes of this market where required, you deal with at 564, please.
It's page 564 we're talking, or no?
Yes, please. It's the answers to questions.
Okay, sorry, bear with me, please. Page 564 I have, yes.
And it's, just to put this in context for you, because it's lots of sub-questions.
Yeah.
The question began at 5 on the previous page.
Okay, yes.
You were asked, insofar as there are no sales particulars, all the following information is not provided in such particulars.
Okay, yes.
Please confirm. And then G, a copy of any valuation or valuations of the trust assets, and if that is not available, the full reasons for the valuations given in your report, and the identity and professional qualifications of the person who carried out the valuation.
Yes.
And you say that in the last sentence, when the asset is residential property, valuation will usually be in the form of a drive-by valuation by a local estate agent.
Okay, yes.
Not a very robust valuation, is it?
Going round, I think there are practical problems in the market in which, in the reversionary interest we sell, life tenants may well be elderly. Sometimes you have a life tenant who is stepmother to remainder men, children from first marriage, and there's no love lost. So you either got elderly life tenants, you've got life tenant remainder men who don't get on. So getting a surveyor through the door is not always an easy thing to do. Investors are happy with that drive-by approach. I do know that a number of them will contact other local estate agents to get a confirmation of value, and I do know that some of them will actually go and visit the area, do their own drive-by. Best for reasons.
I'm not sure if it was just me, Mr. Watson, but your feed was cut off at the very beginning of your answer, and I'm not sure what the beginning of the answer was.
Okay, well, yeah.
The question I had was that a drive-by valuation is not a very robust valuation.
And the beginning of my answer was to say I agree it's not as robust, for example, as a surveyor going around and doing a full structural survey. Then went on to say that there were difficulties, practical difficulties.
I think we all heard that bit.
Okay, fine. Okay.
Just while we're on this page, Mr. Watson, we touched earlier on about the trust terms. That was question H. You can see that just below where we are.
Yes, yeah.
And we asked to provide the terms of the trust involved,
yeah,
including any terms to protect the assets against dilapidation or deterioration. And your answer is given just beneath. You'd just like to remind yourself of that.
Yes, yeah, I think we discussed that a little earlier, yes. But
yeah, but if we look at question 14, turning forward on this topic, page 571, please.
571.
You're disappearing. Can you speak up a little, please?
I'm so sorry. I'll turn up. I will move closer to the screen, my lord.
Thank you.
Is that better?
Yes. 571 I caught, but not where we were going within it.
Question 14, my lord.
Thank you.
Okay. Yeah.
At the top of the page.
Yeah.
We asked you a question whether you agreed when considering net yields, allowance should be made for the expenses of realising such income.
Yes.
And your answer, you agreed, where they exist, which is not often, I like to have access to trust accounts so that I can see what expenses are involved. It's my understanding that most trust expenses are usually deducted from capital.
Yes.
So if all the costs, if you're buying a reversionary interest, you're buying capital.
Yes.
And so if all the cost is paid out of the capital, it impacts on the value of the reversionary interest.
Yeah, I mean, I think question 14 was in the context of, your question 14 was in the context of my, what I call fair and reasonable approach, but you're right, well, you're right that costs, or trust costs, other than, will largely come from capital. I'm just thinking of trustees that I've seen. I mean, it will often be made, and this is from memory rather than having had the opportunity to go back through to my files in the immediate past, the condition of somebody being given a life tenancy in a property as part of a will is that they will insure it, maintain it, etc., etc. So that my reading of that is that it would not be the trustees and trust capital that would be required to be used to pay for insurance and pay for maintenance.
Without the trust particulars, though, we simply don't know what the particulars were in each particular case.
I accept that, and I suppose the other point to make is that having seen the specifics of the trust deed, if investors, some will have walked away, others will have been happy to make bids and buy the reversionary interest.
All right. Can you turn back to 538, please, in your main report?
We can. Yes.
At 5.5,
Yeah.
You make the point that most commonly we are asked to advise on how to divide the trust assets.
Yes.
And so the larger part of your job is advising on what a fair and reasonable division of the assets is between the life tenant and the remainderman.
Yes. Well, I spend much more time doing that than talking to people who might want to sell the reversionary interest.
Indeed. I mean, we can see from the number of sales that you spend much more time doing that. It's by far the bigger market, isn't it?
Well, I wouldn't use the word market. It's certainly, I earn more of my income from advising on fair and reasonable than I do from assisting with the sale of trust interests.
Certainly. And you, both you and Mr. Robinson have done a fair and reasonable valuation.
We have, yes.
Different bases. You adopt the rental valuation approach, and he adopts a mixed fund of assets approach.
Yes.
Can we look at your rental yield approach, please? First point is, I asked Dr. Llewellyn yesterday whether valuing the cost of ownership by reference to the cost of rental was comparing with like, and he agreed with me that it was not. Do you agree with that?
I don't know, I'm not an economist, and the context in which I use rental yield is not the same. I'm quite happy to explain to the court in a bit more detail why I use a rental yield when I'm asked to advise on a fair and reasonable partition where a life tenant occupies a property. So,
can you? I think you.
Well, Mr. Ordered, I think if Mr. Watson wants to explain, he probably should.
Indeed, my lord. What I wasn't sure is whether the explanation was more than what is in the report.
You have explained, I think, in your report.
I think it may be useful to sort of compare and contrast the approach I use with Mr. Robinson's, which, I mean, obviously I haven't seen Mr. Robinson's report before, but by the time I finished my report.
But in terms, just to deal with his lordship's point,
yep.
You said you could explain why you adopt the rental yield. You have done that in your report. I think that what we'd like to know is whether there's anything else you wish to add to what's in your report about why you adopt that approach.
Well, if I can say briefly, I mean, my approach when I'm asked to advise on a fair and reasonable apportionment, and I might be asked by life tenant advisors for life tenant remainderment or trustees. And I think the first point to make is, in my experience, it's rarely the case that there's a done deal, that all parties have agreed to an apportionment partition of the trust. So, you know, one or other parties come to me so that they can get some numbers that they can approach other parties with, or the other parties come to them with some numbers and they want independent advice. So my starting point, which differs from Mr. Robinson's, with an ordinary trust in stocks and shares or a property where rental income is being received, is to try and say what is the present value of what you, the beneficiaries, life tenant remainderment, are currently receiving from the trust. So I take into account the current year on the trust assets, which seems to me, that's what you're getting at the moment, and subject to actuarial assumptions and the caveats around actuarial assumptions. This is the present value of your current expectation. So I don't adopt Mr. Robinson's hypothetical portfolio of gilts and equities. The problem I then have is that when I'm asked to advise on a partition of a trust where there's a residential property that the life tenant lives in, there is no income that I can say to the life tenant, the present value of your interest is X based on what you're getting at the moment. And my solution to that problem, which may well be imperfect and there may be other ones, is to say, well, you've got rent-free occupation of that property. It seems to me that the rent you would otherwise pay is a reasonable proxy that I can use to calculate the present value of what you are currently benefiting from the trust.
Yes, so you're using rent in a case where the home will never be rented out, or the property will never be rented out.
Well, other than the trust terms may at some stage, the trust terms may say that the property, if the life tenant leaves, the property can be let out and the life tenant could receive the rental income, but that won't always be the case.
Do you agree that owning a property without borrowing is a much cheaper alternative to renting?
I guess that's what I've always been brought up to believe, but that's just my personal experience, and I'm not an economist. If you asked me the statistics on that, I couldn't give it to you.
All right, but at the end of life, obviously there's a crucial difference between renting and ownership, which is the capital asset. With
Yes.
rent, there's none left. With
Yes.
ownership, it's all left.
Yes.
Just, if I could ask you whether you agree with the point made by Mr. Robinson in relation to rental, because he was asked about this as well. Could you turn to 601, please?
Yes, got that.
This is his answers to questions, and the question began on 600. Could you read the questions yourself?
Okay, yes.
And then please read his answer.
So, yes, I've read his answer.
Is there anything in there with which you disagree when he compares the two markets?
I'm not sure that I fully understand the first paragraph beginning clearly.
Well, essentially what he's saying is that they are two different markets affected in different ways by a host of different factors.
Yes, okay, yes, then fine.
And you agree with that?
Yes.
In this particular case, it isn't, I'm going to suggest to you, pragmatic or possible to use rental because we simply don't have any valuation evidence, do we?
I can't remember all the details of the accommodation experts report, but if that doesn't include some information about rent, then something that's specific to Miss Swift's case, the claimant's case, isn't available.
No.
Mr. Rawdon, I'm not sure for myself how that's a helpful question, because unless I've missed it, Mr. Watson doesn't give a specific yield for this property. What he is doing is giving an overall opinion on the approach to valuing properties of which he himself says are different kinds. Has anyone asked him to provide a valuation of the reversion on the specific facts of the case as found by Mrs. Justice Lambert?
No, my Lord, I'm well aware, obviously, that Mr. Watson indicates that his rental figures are illustrative only. But one of the questions for this court is whether it's a practical and the best solution if you don't adopt the market value. And what I'm exploring with Mr. Watson now is what is required in each case to reach a rental valuation.
Well, forgive me, it sounded like the question was skewed towards the facts here.
It was.
Perhaps you could repeat it so that I can understand how you think the answer will be applied.
That question was because primarily the decision that your lordships have to reach is on the facts of this case. But insofar, what I'm about to go on to do is to establish with Mr. Watson what he regards as necessary to provide a rental valuation.
All right.
Mr. Watson, you deal with this at 1019 in your report at 546.
Bear with me, 546, yes.
And essentially, you say there in the second line, I will ask for an open market vacant possession valuation and an assessment of the likely rent that the property would generate if let on the open market.
Yes.
And from that, you then calculate the yield.
I do, yeah.
And you make the point in 1020, the following paragraph, that rental yields vary enormously. It's towards the bottom of that paragraph.
I do, yes.
You give a range of between 2 and 8%.
From that particular source, yes.
Yes. And from that source, insofar as it's material, you confirmed, we needn't go to the actual answer, but you confirmed that that source, namely totallymoney.com buy-to-let yield map,
yeah,
gave a yield in W8, which is London, of 2.05%.
Yes, I think yes, we agree that, yes.
At 1019, you say, going back up, you say that you then calculate the rental yield net of tax.
I do, yes. Yeah.
And you do that in your answers to question 6 on page 565 to 566.
So, 565
to 566.
Yep, okay, yeah.
And what you do there is you deal with each of the examples in turn on the second of those pages.
Yes.
And we can see from the third line of each example that in some cases there's no inheritance tax, and in other cases it's 40%.
Yes.
You've dealt with inheritance tax. One would also need to consider income tax, wouldn't one, if one was considering rental yield?
Yes, and so in 1019, if we're talking about my fair and reasonable approach, then I think I say in 1019, I calculate a rental yield net of basic rate tax.
Yes, and that the impact of tax would vary for any particular claimant depending on what other income and assets they have.
Yes, if I'm writing fair and reasonable report, I take the view that allowing for the individual circumstances of all of the beneficiaries is difficult to do. So all I look at is the after tax, the tax position of the trust itself, rather than any tax that beneficiaries might.
So for personal injury claims, that would suggest that it's going to involve issues of taxation to be able to calculate net yield.
I need to think about that. I mean, as I say, in a trust, trusts are liable to tax at basic rate. Beneficiaries maybe have further tax or indeed tax refunds. I need to think through
All right.
that one.
Can we go back to 571, please? Question 14, which we looked at a moment ago.
One, yes.
Now, in your answer there, you agreed that in calculating net yield, an allowance should be made for the expenses of realising that yield.
So just remind me which question it was. Sorry, I'm on page 57.
I'm so sorry, question 14.
Okay.
Would you be precisely? Sorry, yes, 14. Yeah.
Okay, I've read my answer. Sorry.
You agree that in calculating net yield, allowance should be made for the expenses of realising that yield.
I do, yes.
And you didn't, in your answer to question...
Sorry, just to say that I think most of the normal expenses that a trust would incur in having a tenant living in a rental property owned by the trust would come from the capital rather than from the income that's then passed to the life tenant.
And then in your answer to question 15 was, in your calculations, do you make any allowance for the expenses of letting a property, agency fees, voids, insurance, and so on? You said you don't. And you then say, I think the way to look at my rental yield approach is that it's an objective measure of the benefit to the life tenant or the claimant. So the life tenant or claimant can be considered as a long-term tenant, not a landlord suffering the expenses.
Yes.
You conclude by saying the yield in my calculation reflects the saving to the life tenant or the claimant of not having to pay rent.
Yes.
And that's why you say the gross yield best represents the value to the claimant.
In this particular case, yes.
And you say in your answer to question 18 over the page, if I just allow you to read the whole answer.
Okay, shoot away, yeah.
I think you accept here that doing it in this way values the life tenant's interest rather than balancing the two interests and favours the life tenant.
I'm not sure I would use the word favour, but certainly what I'm doing is saying here is using the rental yield seems to me to be a reasonably practical, objective way of measuring the life tenant's interest, where the life tenant's got a right to occupy the house and therefore by deduction the reversionary interest falls out.
Yes, I mean, it was my word, not yours, in fairness to you, Mr Watson. I was referring to the passage at the bottom of the page, where you say use of a gross yield results in a higher value being placed on lifetime interest.
There's I can't remember whether it was in my answer to your question or elsewhere in my report, if you use a net yield, that tips the balance in favour of the remainder, and if you use a gross yield, that tips the balance in favour of the life tenant. And I don't think there's a right way of a right answer to that, other than to note that it's a judgment that somebody has to make.
In your original report, weren't you in fact using a net yield approach? Can I ask you to look at paragraph 1017? It's page 545, please.
1017, yes, certainly. But
you perhaps to put it in context, you've begun 1016, Mr Watson, by saying my approach in such cases is to base my calculations on the yield on the trust assets net of basic rate tax.
yes.
And then if we drop down to 17 in the second sentence, well, perhaps if I just ask you to read the whole paragraph to yourself, in fact.
Yeah, I think what you're saying is if I were advising on a trust where a life tenant occupies a property, I have a dilemma about whether I should use a rental yield net or gross tax, and my normal approach is to use one that's net. Otherwise, that favours the life tenant, the remainder. If, for example, the life tenant was receiving investment income rather than having the benefit of occupying a property. So in my normal work, I use a net yield, and I give caveats to that in my reports.
Yes, so I'm right in thinking that when you wrote your report, you were using a net yield approach.
I was using a net. I was and would normally doing a fair and reasonable value, not in the claimant's case, but advising on a trust, then I would use a net rental yield. Yes.
Yes, because otherwise.
That's something. But when you say net, we're talking about net of tax.
Net of basic rate tax. Yes.
Because what we have previously talked about was net of certain expenses.
Okay. Yes, sir.
Well, we moved back to net of tax. Yeah.
Because you say in 1017 this most closely reflects the income which the asset would generate.
Yes.
And that is generate to the investor.
Yes.
So you're looking at it there as a yield for the investor, not as a saving to a life tenant.
Well, the net result is the same as you say, but really what I'm trying to do is bring a judgment about how I would advise if I had an identical trust, one of which the life tenant gets rental income from a property. That life tenant's twin brother lives in an identical property. If I was asked to advise on a fair and reasonable partition of both trusts, I have a dilemma, a practical problem, where the life tenant occupies the property. They're getting effectively a tax-free benefit. So my advice one could argue my advice should be that the life tenant who occupies the property should get a bigger slice of the cake than his brother, who is twin brother, who's getting rental income. But if I do that, then the reversion, the remainder man on the other side of who's going to get the rest of the cake will get more or less. And I have decided in my normal work, I would prefer to use a net yield. But to solve what a solver doesn't, but to reflect that conflict.
And to address his lordship's point, if we're looking at a net yield in terms of the income the asset would generate to the investor, and the expenses of maintaining the asset came out of the trust, i.e. out of the capital, you're looking at it net of both expenses and tax, aren't you?
No, I mean not the rental income. The rental income would be net of such expenses that are chargeable against income.
The rental income would be, but the net yield on the asset would have to take expenses coming out of the capital into.
Yeah, yes, I take your point. Yes, yes.
Now, so it sounds like your view is the rental approach, whichever you go for, net or gross yield, favours one or the other, but doesn't balance them adequately.
Well, it favours one or the other. There's a judgment to be made about which one to use.
All right. Have you,
Mr. Alden, could I just ask this? Presumably, when you give advice,
yes,
on a fair and reasonable basis, it can be to the life tenant, it can be to the remainder men or a group of the remainder men.
Yep.
But your advice results in a negotiation.
I mean, the reality of the situation is I send a report off and very rarely hear anything else. I'm not involved in negotiations, so I assume my report is, as you say, used for a round table or taken off to other parties and say, what do you think? And they come to conclusions, or they don't come to conclusions and nothing happens.
Okay, thank you.
just to pick up on that point, Mr. Watson, are you approached sometimes by both the remainder men and the life tenant to reach a fair valuation?
But as I said, or I said earlier, almost all of my instructions come from solicitors, and sometimes the solicitors will be acting for the trustees. Now, whether it's the trustees taking the initiative, saying, you know, this trust is more trouble than it's worth, let's divvy it up, or whether the trustees are acting because they've been approached by the remainder men, I don't know. I can't think of a case where life tenant remainder men, without a solicitor being being personally instructed, me coming and saying, this is what we plan to do.
Do you ever do a fair and reasonable valuation in the sort of method adopted by Mr. Robinson?
No.
You never do?
I mean, for the reasons I explained earlier, my philosophy, my approach is to want to say to the beneficiaries, this is the present value of what you are getting at the moment, and make a judgment about what you're being offered in the dividing of the cake based on what I hope is a fair and reasonable assessment of what you are getting at the moment.
But you don't regard it as an unreasonable approach to take?
Well, I have to be honest, I don't. This area of actuarial work is very niche. I don't think Mr. Robinson may tell me I'm wrong. I don't think the actuarial papers have been written about it. But for 40 or more years, when I started doing the work, I went back through those papers, and the assuming a sort of hypothetical, which I don't mean to be derogatory, portfolio like Mr. Robinson, or based on the yield of the assets of the trust like I use, were all mentioned. To the extent that I've seen any other actuaries' reports, and I rarely do. Coincidentally, I saw one produced by one of Mr. Robinson's colleagues in my more normal, fair and reasonable work fairly recently that used his approach. Others that I've seen, or other actuaries I've spoken to, and this is not a deep and wide survey. I think the only time I've come across his approach is in those two cases from his firms. The few other cases I've either seen or actuaries I've spoken to tend to use the yield on the trust approach, but that's by no means a definitive survey.
In most cases, you write a report and hear no more about it.
I think that's yes, yeah.
May I just have a moment, my lord, please?
Yes, of course, Mr. Rutland.
Thank you. Mr. Watson, just one more question. The other cases which aren't the 3 in which you've given particulars,
Yes.
referred to 10 cases, are you able to provide those particulars?
Yeah. I mean, not in the sort of next 2 hours, but certainly, given a reasonable amount of time, I could go through the files and sort of photocopy them. I mean, they will be of the same quality or lack of quality of the ones I gave you in my responses.
Yes. Well, could I ask you to do that when you're able to do it?
Yes. I mean, is there a time to scale
I think that will ultimately be a matter for the court, Mr.
Okay.
Watson, but you're very willing, you're perfectly entitled to ask whether he's able to do so, and you've got your answer on that, and then we can pursue it later whether he should be asked.
I understand that. In which case, Mr. Watson, those are all my questions. Thank you very much for your assistance.
Thank you.
Now, Mr. Sweeting, if you were going to ask the court's indulgence to ask any questions, now would be the time, but maybe or not.
I'm not going to, my lord. Thank you very much.
Very well. Mr. Allen, do you have any re-examination?
Only on 3 points, please, my lord. Mr. Watson, you were asked questions about the impact or the effect of age upon rental yield.
Just say that again, sorry. Impact
You
of
were
age.
asked questions about the impact of age upon investment yield in terms of market value.
Yes.
And I think the explanation you gave was that age can affect the value, the ultimate valuation of the reversionary interest, but doesn't, in your view, affect yield.
Yes, I thought we could, Mr. Orton and I had resolved that being at cross purposes. It's certainly the case that the longer the life expectancy, and I guess that normally means the younger the life tenant or claimant, then the lower the value or the price that their reversion would get in the market. I don't think it's necessarily the case, and I don't have any evidence one way or the other that yields will change by a different yield would apply to somebody with a 10-year life expectancy than somebody with a 20-year life expectancy.
Thank you. 2, Mr. Rowland asked you questions about the size of the market for reversionary interest.
Yes.
And you touched on its potential for the future. What impact, if any, might the introduction of personal injury claimants who wanted to sell their reversionary interest have upon the market?
But I think that the reversionary interest we're speaking about in this particular case are sort of analogous to what investors have shown a willingness to buy. We have more, with all the caveats about small market, we have more people who are interested in buying reversionary interest than we have reversionary interest to sell. So I think the market would accommodate a flow of these without flooding us. And I guess it depends how many the courts and the market might throw at us. But certainly a handful of new cases each year would be good news, and I think sellable.
Point number 3, and again, just to avoid any confusion, there were questions about the suggestion that your approach to market value might overvalue the reversionary interest in the context of the life interest, the marriage value, and the reversionary interest. Just so we are clear, does market value risk overvaluing the life interest or overvaluing the reversionary interest?
Well, we're talking market values rather than fair and reasonable here, aren't we?
Yes.
I mean, what I think I've said is that if the market value, if the reversionary interest and the life interest of the same trust were sold at the same time, the sum of the two market prices sold to independent third parties, etc., would be less than the value of the total of the property, the £900,000 in this case. The difference is the marriage value, how much of that is attributable to the claimant and how much to the life tenant and how much to the remainderment of the reversionary interest. I'm not sure. I think both would be entitled to a share of the marriage value.
Does the court have any questions?
Yes, I have one, arising really out of the last question you have asked. Mr. Watson, is it possible in your experience to give some idea of the relative proportions of life interest without marriage value, reversionary interest without marriage value, and the marriage value? So if we were looking at the broad range of yields which you have put in your evidence, to what degree might that probably be corrected to allow for the marriage value which can't be built into it?
A difficult one. I think one problem is that the market in life interests is very, very, very small. Even I can't dispute that. So I think there would be no real evidence or market evidence on which to say this is the market value of the life interest to put into that equation. I'm thinking aloud, whether one would look at a fair and reasonable. I would argue on my approach. I guess that, as we know, there are other approaches to fair and reasonable. If one was to compare the market value of the reversionary interest to the fair and reasonable value of the reversionary interest, is that the share of the marriage value that that it's fair to attribute to the reversionary interest? I'm not sure. That sort of sounds like it might be right, but I wouldn't want to go to the stake on that.
So that the difference between the fair and reasonable yields and the market value outcomes, that might be the reflection. Is that what you're saying?
I think that's what I'm
fair reflection of the marriage value.
I think if the market value for a reversion would, let's say a gross rental yield, or let's say that I was doing a fair and reasonable calculation using 3%, if we assume that was right, but my market values are calculated at 6%. If the market value trends towards 3%, using a yield of 3%, then the marriage value is closed. So the marriage value arises because we're using, say, 3% in fair and reasonable when there's no marriage value, and a yield of 6% for market values.
Right. I don't know whether council want to ask anything arising from that, because it's something I've opened up.
Mr. Order, there is wish to, Mr. Allen, likewise. Does my lord have any other questions?
No, thank you.
My lady?
No, thank you.
I don't. Thank you very much indeed, Mr. Watson.
Thank you very much indeed. Thanks.
Yes. Now it's Mr. Robinson to be called by Mr. Alden, I'm assuming.
Yes, my lord, thank you. Mr. Robinson, could you switch your camera and microphone on, please?
Hello.
Mr. Robinson, if you could start like the other witnesses have, I hope you've been given a copy of the form of words for your oath or affirmation. Could you proceed to swear or affirm as you prefer?
I do solemnly, sincerely and truly declare and affirm that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
Thank you. Is your full name Daniel Robinson?
Daniel Alexander Robinson.
Thank you. And I think you've set out your credentials, qualifications and credentials in your reports, which we find at tabs 18 and 19. 18 is your main report, starting at 575 in bundle 2, signed by you on page 596, and that dates from February of this year.
Yes.
and then you were asked questions by PIBA, and at the following tab, starting at 598, we find your responses through to page 609.
That's correct.
You confirm that those two documents contain and represent the opinions of yours in this case properly.
That's correct.
If you wait there, there'll be some further questions.
I'm assuming it's coming from Mr. Allen, is that right? Or from Mr. Sweeting?
From me, Mr. Sweeting, my lord.
I don't know why I thought it would be Mr. Allen. I wasn't clear. I think perhaps the questions were asked by PIBA, but that's fine as long as that's what's agreed.
Thank you. Good morning, Mr. Robinson.
Good morning.
Could I ask you please to look at page 581, which is section 3 of your report?
Yeah.
Now, at the top of that page, you say that you're often asked to provide a fair apportionment of life interests. And a little bit further down, at the foot of paragraph 3.2.2, you say that I am not, however, an expert on the markets for interests and trusts or their market prices. So, do I take it, Mr. Robinson, that all you're able to give opinions about is a fair apportionment of life interests where both the tenant and the remainder man have agreed to apportion the trust assets and convert them into cash?
I wouldn't say that. I'm not an expert in the market price of life interests and reversionary interests, but I am an actuary with expertise in valuing uncertain future cash flows.
But the position is, isn't it, that you're required to, or asked to give that advice, essentially in circumstances where the parties want to bring to an end the arrangement and both are willing to sell.
Yes, in these cases I'm talking about here, that is correct.
And in your report, you do not attempt to provide a market valuation, don't you?
A market value, no, I understand it's only Foster, Cranfield, Mr. Watson who provide that service. I'm not asked to be involved in buying and selling of reversionary or life interests, only to place a value on them.
Yeah. In fact, a little bit further down the page that I referred to you to at paragraph 3.4, you say, I have no professional experience of the market for reversionary interest or life interests to be bought and sold. So essentially what your report does is give illustrations in respect of a fair and reasonable value.
It gives that and comments on other approaches, but doesn't comment on the market value, except to say that I believe it's small from my dealings with lawyers.
And what your advice is generally intended to do in the circumstances with which you are familiar is to strike a fair balance between the interests of the life tenant and the remainder man.
That's correct.
Yeah. If you turn over the page, please, to 582. Under the heading Considering Fair Compensation for All Cash Flows, you start by saying that as an actuary, your preferred approach would be to model what will happen in the future using probabilities and so on to forecast what funds the claimant will need. And then at 3.14, you say the problem with this approach is that the method cannot be condensed to a table of factors that can be used in each case without reference to an actuary. Now that's a way of saying, isn't it, that if you're going to model a cash flow, in each case, you wouldn't be able to do it by reference to a table in which you could look up a yield, for example. You would have to consider, with the help of actuarial evidence, the individual case.
Yes. so there are actuaries available.
Sorry, Mr. Robinson.
I'm saying that actuarial advice is my preferred approach for solving these problems.
But what you actually said is that there are actuaries available.
Yes, actuaries available to do that work.
Yeah, I'm not disputing that, Mr. Robinson. It's just that if you're going to approach it on the basis of a cash flow, which I think you say might be regarded as arithmetically the perfect actuarial approach, you would have to do it by reference to actuarial evidence and advice in each case.
Correct.
Yeah. If we turn on, please, to page 584, you start to deal there with a fair and reasonable apportionment of life interest trusts. And you describe the typical life interest trust as one which is created when a married person dies, specifying in their will the family house may be lived in by their surviving spouse for the rest of their life. On their death, the house will then be sold and the proceeds divided between all the children, perhaps including those from a former marriage. And that is the usual sort of situation in which you are giving your advice. Would that be right?
It's more often than not that is the case.
Yeah. And if we look down to paragraph 4.5, you mention something that you say it's important to note. And that is that you are not asked to place a market value on either the life interest or the reversionary interest. That you add the caveat that if there were a perfect market in the economic sense for these interests and other financial products, no need for prudence, then I would expect to arrive at a market value through my calculations. That's a sort of, all things being equal, my process would produce a market value.
Yes.
And the reference to no need for prudence is a reference to no need to make an adjustment one way or the other in favour of one party or the other.
That's correct.
Yeah.
And also no need to take into account the risks and the effect the risks will have on one party or the other.
You say also, but in fact that is what you mean. Prudence is a reference to the risk acceptability to the party in question.
It can either be reference to the risk, I think, in general, or different parties' approaches to the risk. So the person's life expectancy, getting an income for life is not a risk for a person, but getting an income for somebody else's life is more risky because you don't know when they might die. It's a technical point.
Yes, well, there are certain externalities, aren't there, in the assessment, the calculation that you're setting out, all of which potentially involve a risk, because you are required to make assumptions about the future.
Yes.
And so if we look over the page, please, to 585, you describe the calculation method. I'm not going to read out large portions of this, but if you look at the bottom of the page, 415, you say, for the choice of assumed assets, where the trust contains a property, it may well not be essential in my opinion to analyse the property in detail to determine the notional rent and the expected property price growth. And the reason for that in your paragraph, which is because at that stage the intention is to sell the house. Yes.
Yes.
That has another benefit, doesn't it, Mr. Robinson, which is the one you mention in the next paragraph, which is that the rental yield may not be known, and it may be difficult to find a completely reliable estimate of future house price inflation. Because that would be one of the externalities, wouldn't it? One of the future risks and uncertainties that you would otherwise have to take into account.
Yeah.
If we go over the page to 586, you deal there with your calculation results, and you set out the discount rate that you've used for the purpose of the calculation that you make lower down the page. And you say at 4.23 that the value of the life interest calculated using this method is 900,000 minus 552,000, that's 348,000. But then you add, the choice of discount rate is very subjective. It would be possible to argue that rates from a reasonably wide range were appropriate. Why is that, Mr. Robinson?
Because it is so subjective. I think if it were easy, then this case probably wouldn't be here. I'm trying to provide an answer which all sides to an apportionment agree is fair, and the parties may have different views about what investments could yield.
And the other thing that you add in relation to that at 425 is that there isn't a margin for prudence in the discount rate chosen, because in effect, if you introduce that into your choice of discount rate, it would either prejudice one party or the other.
Or you would have to have the marriage value, Mr. Watson discussed.
You put it nicely by saying any prudence allowed for one party would be imprudence for the other party. I think, Mr. Watson, you've disappeared off, Mr. Robinson, you've disappeared off my screen, so can I just check that you can still hear me?
I can still hear you. I do seem to have frozen somewhat.
Well, fortunately, Mr. Robinson, we can still hear you very well, and if you don't mind being in the same boat as me, being a disembodied voice, if nobody else minds that. In fact, you come back.
Okay.
Good.
I think, Mr. Robinson, if you disappear again, as long as we can hear you, I'm going to carry on. So rather than trying to wait for you to come back onto screen. And so if you did have to introduce prudence into the equation, you would effectively have to choose which of the parties you were going to favour, if I can put it like that.
I would, because I'm trying to arrive at something that all sides see as fair and agree to, I think I would let them decide where the prudence lay.
Right. If you turn over the page, please, to 587, at section 5 of your report, you are discussing using a discount rate which reflects a rental yield. And at paragraph 5.4 you say, as I understand that there is no intention of renting out the special accommodation, it's not clear that this approach has any relevance to this case. Is that your overall view about an approach using a rental yield?
Yes. I think a rental yield is useful where a property is being rented, or more useful in those cases.
And although you go on to make some assumptions and calculations in relation to this approach, those are prefaced at 5.6 and 5.7 with you making the point that you're not a property expert and neither are you an expert on the costs of a landlord.
That's correct. So that's why I referred to the government actuaries report.
Right. At 6, which we find at page 589, that's starting from the Lord Chancellor's discount rate. You say at the top of the page, although I believe that actuarial calculation should be pragmatic, it's possible to revert to theoretical principles and imagine a world where there is a deep market in any type of financial product needed, where all market prices are fair, and that makes actuarial mathematics much simpler. I think you then go on to discuss the approach if you are to use the Lord Chancellor's discount rate. Again, I'm not going to ask you questions about the rest of that page, but if you turn over to page 590, your final conclusion on that at 6.8 is, this is a hypothetical actuarial exercise, so I'm not intending to arrive at a real-life market interest rate for a loan over the life of the claimant. The huge uncertainty in this scheme to construct a life interest is whether the interest added on to the loan amount builds up over the years to be more than the house proceeds, and so on. And then at 6.10, this addition to the discount rate for prudence is in contrast to the typical actuarial calculation where prudence requires a deduction to the discount rate. Again, if you're adding in prudence on the basis on which the Lord Chancellor has adopted a prudent approach, that is different from the approach that you would take on a purely actuarial basis.
Yes, if you're investing or borrowing, the prudence needs to be put in the other direction.
And then you deal with the question of what happens if you reverse the Lord Chancellor's margins for tax expenses and prudence. You get that at the bottom of the page 590. But if we skip over the page to 591, we can see what the ultimate conclusion is. That's at paragraph 620. Other than the attractive symmetry of using a different discount rate for positive and negative cash flows, I do not see any good reason to follow this approach. So you don't think that that adds or illuminates any of the questions which we're facing in this appeal?
I think it illuminates it, but I don't think it's a perfect solution to the problem you're facing.
And can you turn on, please, to page 593? When you are considering fair compensation based on a cash flow analysis, can I direct your attention, please, to paragraph 7.5? You say this, as set out above, a typical future financial loss case involves determining the size of a pot of money which, when invested safely in low-risk assets, will be expected to be able to meet future costs. But then you identify a problem with that. You say a problem occurs if the money is expected to run out before all the costs have been met, even if there is the expectation of a future windfall, as then the calculations need an assumption of how this problem will be resolved. Reversionary interest in the calculations can make this problem more likely. What did you mean by the last sentence?
So, if it's a reversionary interest that is due on the death of the life tenant, then the windfall is going to happen. If, on the other hand, it was assumed that the life tenant or claimant in the last 10 years of their life would move into nursing care and sell their house, then the windfall could be used to pay for that. So it's not necessarily always going to result in a windfall at the end of the person's life.
Right. And then if you turn on, please, to page 595, you've got a heading which is results from treating the cash flows as a whole. What we're dealing with here is what we've just been referring to, the idea that you produce one cash pot and then you deal with the question of the ability of that pot to generate enough income to meet the claimant's needs. That's right, isn't it?
Yes.
And you say here, it's possible that incorporating the value of the windfall into the cash flows in this way, just pausing for a moment, that's quantifying the windfall from the property at the end of life and bringing it into the equation on the basis that the claimant can access it at an earlier point. That's what you're talking about.
That's correct.
Yeah. And you say it could result in the value of the accommodation claim being below zero if it were artificially split out from the other costs being compensated for. Can you just help us with what you meant by if it were artificially split out and so on?
So I'm not clear, I'm no lawyer, I don't know why there are heads of damages, individual pots that can't go below zero, but if you regard the claimant as having individual pots of money which aren't going to be intermingled during the course of the investments that she makes, it seems an artificial assumption that the money wouldn't get merged together when she receives it.
So can I ask you then to turn to page...
Mr Robinson, do you mind if I just ask a question on that? If that observation applies to the windfall, why does it not apply across the board to any other pot of money which the court finds is needed on a discounted basis, adopting all the calculations we do?
I think it should account. It should apply in all cases. I don't think accommodation is a particularly special case here.
So your observation would apply to the whole way that the courts calculate personal injury damages?
I'm afraid so.
Well, I think we may see a summary of that at page 596, where I was going to ask you to go next, Mr. Robinson. Paragraph 8.4, you say the solution is not complicated if the claimant is going to have certainty of being able to pay for her costs. And you say start with a pot of money and deduct or add cash flows out or in as they are expected to occur, adjust the funds for anticipated investment returns, and make reasonable assumptions about what the claimant will do if the funds are expected to go overdrawn at any point. And that's what you were describing a moment ago in answer to my Lord's question, wasn't it?
I think my Lord was asking about whether pots should be divided. That's what I was answering. This is talking about when you have assets that aren't cash or expected future cash flows, how you account for those in your calculations, expected future cash flows coming in.
Well, let me ask you to deal with a simple damages claim then, which is a claimant, an injured claimant who needs physiotherapy, which will cost £100 a year for the rest of her life. How would you value that claim?
I would discount each of those cash flows back to today's present value. I would look at the probability in each future year that the claimant would be alive at that future date. I would multiply the discounted values by those probabilities and then sum the answers.
Well, in other words, you would produce, wouldn't you, a multiplicand, and you would discount it by reference to a multiplier.
I think that's probably how lawyers describe it.
Yeah. And if we were to add on to that a claim for occupational therapy of the same amount each year for the same period, you would do precisely the same again, wouldn't you?
Yes.
And the addition of those two claims in that very simple example would produce a pot of money.
That's correct.
But if the claimant in fact went and invested that pot of money in high-risk equities, would you then say that some further step is required?
Some further step was required at which point, sorry?
Well,
I'm not trying to understand the question, Mr. Sweeting.
Well, perhaps I can put it in a different way. If that pot of money, which we produced from those two examples, is then invested in a property, does that make any difference?
I think the claimant can do what she wants with the money once she receives it.
Yes. And she hasn't, in this case, has she been given any money to invest in a property? So it doesn't fall to be considered, does it, in her damages claim?
I don't know if I don't think she's been given guidance about where to invest the money.
No. Thank you very much, Mr. Robinson. Those are all my questions, my lords.
Yes, Mr. Oh, perhaps I should ask my lord and my lady first before I ask Mr. Orland.
No, thank you.
No? Mr. Orland, any re-examination?
No re-examination, my lord, thank you.
Thank you again, Mr. Robinson. As I've meant to state to all the witnesses,
My apologies.
Good. No problem at all. Then I'm, as long as we have Mr. Sweeting and Mr. Audland, which I think we do, not that everyone else isn't important in their own way, but they're the only people we actually need to be able to hear from, off we go. Yes.
Well, thank you, my lords, my lady. The complexities of the law of damages for personal injury can really be reduced to a straightforward question. What loss has the claimant suffered, and what sum of money will compensate her for that loss in monetary terms? Now, in answering that question, the court, we would say, has a noble aim, and it's supported by the highest authority, and it's this, that the claimant should be fully compensated for her loss. We find that in Wales and Wales itself, where Lord Lloyd observed it was common ground between all the parties that the task of the court in assessing damages for personal injuries is to arrive at a lump sum which represents as nearly as possible full compensation for the injury which the plaintiff has suffered. And of course, that continues to be the underlying purpose of an award of damages in personal injury. The Supreme Court, more recently, in the case of Nower, said this: it's the aim of an award of damages in the law of tort, so far as possible, to place the person who's been harmed by the wrongful acts of another in a position in which he or she would have been had the harm not been done. Full compensation, no more, but certainly no less. Of course, there are some harms which no amount of money can properly redress. There are also harms which it is difficult to assess, especially for those which will be suffered in the future, but the principle of full compensation is clear. Now, my lords, my lady, it's that settled principle that the appellant seeks to uphold in this appeal. It is in fact the respondent which seeks to advance a case which is unsupported by any authority and indeed contrary to that fundamental principle. At the trial, the judge concluded, Mrs Justice Lambert, that because of her injuries, the claimant would require more expensive accommodation, and that the additional purchase price of that accommodation, when acquired, would be £900,000. Now, those findings are not in issue in this appeal. The question of what loss the claimant has suffered in those circumstances and what sum of money would compensate her for that loss is complicated by the possibility that once acquired, the property is an asset which will or may retain or increase its value over time, so that in contrast to other types of loss, any damage awarded to enable the claimant to purchase the property would not be exhausted over the claimant's lifetime. Thus, there may be what has been termed in the now long line of authorities to be a windfall to the claimant's estate, not to the claimant herself. However, there are two observations to be made about that. Firstly, in none of that long line of cases which have dealt with this topic has a court ever concluded that a claimant in these circumstances had not, in fact, suffered a loss. Secondly, in none of those cases has the court ever sought to quantify the potential windfall and bring that potential windfall into account. The spectre of the windfall impelled the court to characterise the loss in a different way, but it's never been quantified as part of an award. The question has been how the acknowledged loss should be characterised. The answer has been, of course, that what should be compensated is the cost to the claimant of devoting more capital to accommodation and not the cost of the accommodation itself. Now, the practical problem to which that gives rise is that the need to purchase accommodation is an immediate one. but the damages awarded reflect a loss in effect, accruing over time, and so they are discounted. So, why is it that, as we say, the respondents seek to argue that the claimant has suffered no loss in this case? And the answer we suggest is that the respondent's position is untenable once any loss is acknowledged. Mrs Justice Lambert explicitly made awards of damages in respect of all of the other heads of loss which were successfully claimed. She did not make an award of damages in relation to the increased purchase cost of accommodation. So the appellant has received no compensation at all in respect of that loss. She's received no monetary compensation, let alone full compensation, to be attributed to that loss. The respondent, we say, is therefore driven to argue that the appellant has failed to prove, and this is the way they put it, that she has suffered a net loss. Now, she had no obligation to do that. She established that she had suffered a loss in an entirely conventional way, the way in which the courts have always accepted that someone who had to pay more for special accommodation suffers a loss. As I said a moment ago, that has never been the issue. The issue is how that loss is to be characterised and compensated. This argument, the argument that there is no loss, depends on what has been termed to be a cash flow analysis. And we see that developed in the evidence in particular of this angel, although it's apparent, we would say from their evidence, that in effect she has really been doing calculations on the basis of assumptions that she has been asked to make. What the effect of that is to bring into account a calculation of an increase in the value of her property over her lifetime. And instead of that being a windfall to the state, it is brought into account during her lifetime. And it's therefore said to be one way of reducing her need to have any further damages than she has so far obtained. Now, bizarrely, the respondent seeks to take the benefit of this hypothetical increase, even though it has not contributed a penny towards the purchase price. The balance is zero in the damages assessment. Now, we say that that approach is wrong for a number of reasons, both of principle and practice. The first is really an overarching reason. That is simply not the way in which damages are calculated. Damages are arrived at by considering each loss as a head of damage. The principle of siloing each head of damages discretely is well established. It has allowed the modern law of damages for personal injury to develop in a way which is responsive, based on logic and actuarial calculation where appropriate. It's become increasingly more sophisticated in recent times, and the exercise produces a precise and calibrated assessment of what the claimant's loss is in monetary terms, insofar as that can be achieved within the bounds of evidence, practicality, and proportionality. The fact that there is an overall sum is a byproduct of the quantification of separate heads. And so there is not, after that process has been exhausted in the course of assessment, any next step. There is, in the words which the courts have used themselves, no scaling up or down which involves the court in deciding whether and how much of that money should be invested. The court doesn't and shouldn't direct the claimant as to how those damages are to be dealt with, invested or spent. Indeed, the courts are ill-equipped to conduct any such exercise. It's not with respect for the court to tell a claimant with capacity how damages are to be spent. But in any event, there is no need. The claimant has been fully compensated under each head of loss, and if not, there can be an appeal. And because damages are siloed under heads of loss, there can be an appeal in relation to any head of loss in which the court has or may have fallen into error. And indeed, this appeal is just such an example. There is an appeal about one head of damages only. There is no need at the end of a case to see where the courts had got to in lump sum terms and consider whether there should be any adjustment as a result. In Wells and Wells, Lord Lloyd observed, the sum should be calculated as accurately as possible, making just allowance where this is appropriate for contingencies. But once the calculation is done, there is no justification for imposing an artificial cap on the multiplier. There is no room for a judicial scaling down. Current awards in the most serious cases may seem high. The present appeals may be taken as examples, but there is no more reason to reduce the awards, if properly calculated, because they seem high, than there is to increase the awards because the injuries are very severe. That's the first reason. Secondly, the discount rate which produces the capital is not, and certainly not after the most recent change to the way in which it's arrived at, based on any assumption that the claimant invests 25% of her damages in her property. The assumptions made as to investment are set out in the government's actuarial advice. That's in the authorities bundle. The reference is tab 46.
Why do you mention the figure of 25%?
Because, Lord, the 900,000 is approximately 25% of the 3.8 billion sum.
Because that's the facts of this case.
It is, yes.
I'm so sorry, yeah.
No, and a perfectly sensible point to make, if I may say so, my lord, but in most cases, particularly for the reasons that have brought us to the point where accommodation has outstripped other parts of damages, the amount required for the claimant to find to invest in property is going to be a very high percentage. This case, 25%, is not dissimilar to many of those which we come across at the bar on a regular basis where this problem arises.
It would not be difficult to conceive of cases where the percentage was even higher, especially with London property.
It would not be, and in fact, one of the examples which I think I gave in the case of JR and Sheffield in front of Mr. Justice William Davies was of the amputee, the working amputee who has simply suffered an injury which results in a below leg amputation of both legs, for example, who lives in accommodation which is not all at one level and therefore has an accommodation claim, but in fact is going to work, in fact is quite resolute in wanting to live independently and so on, so that the bulk of the claim may in fact be the accommodation claim. And the present position is, in relation to the purchase of for example, a bungalow, which a lifetime wheelchair user would plainly be well advised to do, and the expert evidence would usually point in that direction, there would simply be a massive hole in the case, which wouldn't be plugged by loss of earnings, because, of course, many amputees in that situation can carry on earning, particularly if they do a desk job, and wouldn't be plugged by the need for therapies or the need for care. Someone who lives independently in a wheelchair, it's a perfectly common thing to come across in the personal injury field. So your Lordship is absolutely right that the percentage might be very much greater in terms of what the claimant would have to put into the case. In fact, Mr. Dakin made this point about the fact that the discount rate itself doesn't include any such assumption about the investment of monies in residential property or in the claimant's own property. he observed it would fundamentally undermine the basis on which the original compensation award for other heads of damage was made, since the claimant would not have the whole of the award available to invest in a risk-free manner in accordance with the assumptions underlying the personal injury discount rate, but would instead be required to invest approximately 25% of the award into a single non-interest bearing asset, which is not risk-free, namely their own house. I think, in fact, the assumptions that are made for the purpose of the setting of the personal injury discount rate imply that about 7% would be invested in property, but commercial or other income-producing property, usually in the form of rent. And it's no answer to say, and I suspect this might be what is said, well, it's a pretty good investment, isn't it? Experts have acknowledged under cross-examination that investing in your own property is not a bad outcome. That, of course, is a circular argument because it assumes that the assumptions which have been made and which we'll come on to about how the property market will develop, house price inflation will shape up and what inflation itself will do, are used as the basis for any such assessment. The reality is that the personal injury discount rate has been set on the basis of low-risk investment now, and takes into account a balanced portfolio. And that is what the claimant is entitled to expect and what she gets in terms of the selection of a multiplier in arriving at the lump sum. Now, Mr. Daking, you'll recollect, did some, I suppose, back-of-the-envelope calculations. He readily accepted that they were not as precise because he didn't have access to all the data, but you will remember that he suggested that if you were to assume that there was an investment in the magnitude of 25% in residential property, it would alter the balance of the portfolio which is used for setting the discount rate, so that you would have, in the end, effectively to add £1 million to the overall lump sum. Now, whether that's right or wrong as a calculation, the point in principle is the right one, we say, that you are mounting an attack on the way in which the lump sum is itself arrived at if you are requiring the claimant, in effect, to invest in a way which is not assumed in the calculation of that lump sum. And one might add to that of course, what the respondent is doing is adding in, and we'll get to this when we come to the cash flow analysis, adding in an assumption about house price inflation. And the general convention, we would say rule in relation to the calculation of damages, is that allowance has been made already and once only in the discount rate. And having done that, one doesn't look at multiplicans and seek to add into multiplicans or at any other stage in the calculation an assessment in relation to future inflation. The third point is that the effect of what's being proposed, the cash flow analysis, is that it passes all of what I've termed, I think both in questions and a moment ago, externalities to the claimant. In other words, the risk that over a long period that house price inflation will not be 3.2%, and I'm going directly to the calculations which have been used here, and that general inflation will not be 3.1%. In effect, the claimant has to bear that risk. Moreover, it's explicitly based on an assumption that the claimant will run out of money late in life. It's a very unattractive assumption because in this case we know that the crucial point on the calculations which have been advanced by Miss Angel is that the claimant will find herself out of money at the age of about 80, at a time in life when she is likely to be at her most vulnerable, and at that point will have to release equity in her home. And of course, that gives rise to the last of these points, really, before I come on to some practical matters, which is that there is no evidence at all.
Is this your fourth point?
Well, effectively it is, although in my...
Well, I don't mind at all, I'm just keeping a...
No, I know,
This is you mean it's a sub-point under your third point?
It is a sub-point under the third one.
Yeah.
There's no evidence that such equity release products exist. Indeed, such evidence as there is rather suggests that it's impossible to predict whether or not there will be. Now, there was a point in her evidence, of course, when Miss Angel was suggesting that it might not actually be necessary for the claimant to do that. As I understood what she was saying, she was really suggesting that in practice it might be the case that the claimant would do very much better from her other investments and so on, so might still be in a position to sub herself at that point when she would otherwise run out of money. Again, that is, in our estimation, simply effectively asking the court to roll the dice at an early stage about something which is going to happen very many years hence. So, well, those are my 3 points, or 3 points and a sub-point. But can I make some other observations about why this would be unworkable in practice? And these are these, that the parties simply couldn't assess, if this was the basis on which damages had to be approached, the overall value of the case until the recovery in respect of other heads of loss was known. So at trial, one would have to have an additional step where findings were first made on all the other variables, then expert evidence would be required as to the implication of these findings on the actuarial valuation before a court could consider and determine the award. There would also be the same effect on negotiation, where the parties don't have the assistance of the court in sorting out definitively what the variables are. They have to be conducted by reference to a global sum made up of those individual damages silos, and so accurate assessment would be impossible. In every case, one would need complex actuarial evidence which would give rise to significant, and we would say potentially disproportionate costs. So the court would have to make assumptions again about the externalities, the particular factors which would affect the calculation going forward and forecasting in the future. And Dr. Llewellyn, you may think, gave cogent evidence as to why economics was not perhaps the dismal science that Carlyle said it was. It has limitations in terms of forecasting as opposed to producing projections. His horizon was really a few years hence, rather than the many years which would be required in order to make all of this workable. And my lord, my lady may think that ultimately the respondent has effectively acknowledged that these problems would really be intractable by accepting that this isn't really a solution, a cash flow analysis performed by the court that could be undertaken practically or should be undertaken in every case. And that is why you may think the point is ultimately articulated in the way that it is, which is that the claimant, it is said, has not proved that she has suffered a net loss. As I started this portion of my submissions by saying, she doesn't have to establish that she's not suffered a net loss. Her losses have in fact been assessed by the court in this case in an entirely conventional way. And I think this argument, or this point, really arose in some of the questions which Mr. Auden was asked almost at the outset of the case, I think, when we were looking at what the issues were. He said that this cash flow analysis went to the question of no loss, and it also went to the starting position for reversionary interests. Obviously, I'll come on to whether or not it has any bearing on that in due course. However, if the appellant has suffered a loss, contrary to the approach which is suggested puts her in a position where she can't demonstrate a loss, the question is simply how that loss is going to be compensated. Now, as a starting point, the relationship of a claimant to a defendant tortfeasor is not an equal one. It's a point we make in the opening part of our initial skeleton, which is that the court is not considering the position of those who have life interests in property or tenants and remainder men, not considering those who are beneficiaries under a trust. The need to avoid overcompensation, by which I'm implicitly referring to the windfall, must not lead to undercompensation, because that would, of course, offend the starting principle that there must be full compensation, and undercompensation by definition would not be. I advisedly say the next question need hardly be asked, but it must, of course, never result in no compensation at all. And we say that that is the position the court faces here. There is no compensation at all for an identified loss. The reason for that is not that the learned judge at first instance didn't think there had been a loss or didn't conclude that there had been a loss, but because she, as Mr. Justice William Davies in JR in Sheffield, was not able to identify a mechanism by which that loss could be characterised and made the subject of an award of damages outside of the constraints of Roberts and Johnson. What we say that tells us is that the mechanism in Roberts and Johnson is in fact incapable of quantifying the loss in the changed circumstances of a negative discount rate. It was in fact facing difficulties in quantifying the loss properly, we would say, in the changed economic and social circumstances since the formula in Roberts was propounded. But we now reach a position where it simply doesn't work at all. So the problem, which would be caused by negative discounts, is in fact one which was identified in particular by the learned author of McGregor on Damages in the 19th edition. That's in the Authorities bundle at tab 48. It's perhaps worth, I'm going to read out this portion of it, and perhaps your lordships will just listen to what I read rather than taking time to go to the reference at the moment. It's high time that the Roberts and Johnston problem was tackled and a fair and proper solution found and adopted. The Law Commission looked into the matter some time ago, but found it too difficult to formulate an acceptable solution, and so recommended that the Roberts and Johnson method be retained. The Ogden Working Party is fully aware that the law needs to be righted and has it in mind to investigate the issue in the near future. What could trigger action on this front is a further reduction in the discount rate, the possibility of which, as we have seen, is very much in the air. It is true that as the discount rate lowers, the multipliers increase, but an examination of the figures in the tables in Ogden shows that the increases in the multipliers do not come anywhere near to balancing or offsetting the effect of the fall in the discount rate. And then this, ironically, the injured party will get more for care but less for special accommodation. Indeed, should the discount rate move into the negative, which is highly unlikely, but did happen in the Guernsey case and the Privy Council case of Helmut and Simon, the Roberts and Johnston method becomes unworkable. It would produce a nil award. In fact, logic would suggest that it produces a balance if it is applied rigidly in favour of the defendant, which would be an absurd result, but that's not to say that a nil award is not in itself absurd.
Out of curiosity, when were those observations published?
I think in 2014, but I will check, my lord, and just see which edition, what the date of that edition was.
I wasn't sure that it was in the main work or in one of the supplements, but anyway.
So, my lord, to return to where we are, the Roberts approach, we would say, simply doesn't apply. And that may, in fact, be the simplest starting proposition for the appellant to rely on in relation to the question of whether there is a proper problem with binding precedent.
Yeah.
The parameters within which it was meant to operate simply no longer exist. And once there was a move to a discount rate, whether or not there was any argument about that before, the argument has been decisively settled in favour of saying that the Roberts calculation simply cannot be performed any longer. And also, I see what the time is.
Yes, that sounds like a natural break.
Certainly.
Very well. We'll resume at 2, when you may or may not be able to see me.
Thank you.
Bye.